Good afternoon and welcome to the positive corner of the internet, where Craig Ralph and I have got lots of good news for you about costs in the personal injury context. Or maybe not such good news, but at least things that you need to know about in any event. So what we're going to cover today in very broad terms are the vexed subject of fixed costs. We're going to look at guideline hourly rates and hourly rates more generally. We're going to look at the current controversy over medical agency fees, which has its roots going back at least 20 years. And we're going to look at some developments in relation to QOCS, or qualified one-way costs shifting. The format will be this. We shall bat things back and forth between us. You have, of course, the facility to ask us questions as we go along. And you can either use the Q&A or the chat. And then we'll pick up your questions during the course of the seminar and give you some thoughts based upon matters that you outline. After the seminar, I've asked our people to send you some slides, which simply give you the references of, for example, cases we might mention or papers we might direct your attention to for a bit of further reading. So let's start with the first of those topics, and fixed costs. Now, fixed costs have been in place since last October, but of course there's a bit of a lag as far as most personal injury cases are concerned, because if your cause of action is before the 1st of October, you're still going to be feeding through under the old system. And it's very important to make sure that you understand the transitional provisions. Having said that, although we had a huge amount of law dumped on us last October by way of amendment to the civil procedure rules, the government, through the mechanism of the Civil Procedure Rules Committee, hasn't rested idly on its laurels. And in particular terms, what we're seeing is a progress or process of rolling reform, or running repair, if you want to take a more cynical view, with a further tranche of amendments to the fixed cost rules being contemplated. And it doesn't end there, because beyond that there may yet be more amendments. And of course, we're still contemplating, possibly slightly outside the scope of this seminar, a further tranche of fixed costs for clinical negligence claims. But the big news, it seems to me, is that you have a fixed cost consultation which has now had a response from the government, published in February 2024. It's worth reading it in its totality, because it's not a terribly long document, but what it does is set out 6 key points that are going to change in the near future, as well as a number of smaller ones. The first point is that as far as the government is concerned, there should be fixed costs of the assessment of fixed recoverable costs. That in turn means that there should be fixed costs of Part 8 costs-only proceedings. We also are to have a clear incorporation into the rules that the costs of inquests and restoration of companies to the register will be recoverable as part of the overall scheme. And we have contained within the rules, or to be inserted in the rules, provision for advocacy fees where cases settle or are vacated. So on the fast track, if a case comes out the day of or the day before the trial, then 100% of an advocacy fee will be recoverable, 75% if it's 2 days before. If it's an intermediate cost case, then the advocacy fees will be recoverable to the tune of 75% for up to 5 days before the vacated or settled date. We also will see inflationary uprating for fixed trial advocacy fees above the SPPI figure which has been canvassed to date to take place in April, a clarification of the clinical negligence position, so that any admissions which might direct a case onto the intermediate track must be in the pre-action protocol letter of response. And then the promise on the horizon of a full review in October 2026, with perhaps more fundamental reforms being contemplated. So in a nutshell, that's my explainer as to what the big changes are going to be. Can I pass the baton over to you, Craig, to give your perspective?
Thanks, Andrew. Well, I was rather taken by Andrew's opening in that having been given these new rules that apply to cases that are proceeding after October 23, and so we have two basic regimes operating side by side, we then have this ongoing, running consultation and proposed amendments coming from both the Ministry of Justice and then the Civil Rules Committee. And that is quite a lot of information to take on board. It's quite a lot of information to assimilate. And so from a practical level, it strikes me that practitioners would be well warned, well advised to ensure that they have diarised access to this sort of development and discussion. So, by way of example, I would strongly recommend, and we're going to send some slides out after this talk to those that want them, and they will have hyperlinks within them to various different websites. But I would strongly recommend to practitioners that you look to bookmark certainly the directions that come out of the Ministry of Justice and then the monthly minuted meetings from the Rules Committee. And the reason for that really is fundamentally this. We all have an obligation to ensure that we give, insofar as cost information is concerned, the best cost advice to our clients, both at the outset and throughout. And in circumstances where the rules are being changed, augmented, or just expanded in a manner that perhaps is not obvious from the dominant rules that were set out in October, you could very easily fall to the wrong side of your obligation to give your client the best advice as to costs, simply by omission. Now, whilst we won't go into this at the moment because we're going to deal with it when we turn to QOCS, I think it's also important to bear in mind that there are various matters that are being dealt with, that are being addressed by the Rules Committee, that are by no means certain to come in, but if they do, are likely to have an impact on how you address your client in relation to costs as matters arise, by way of example, offers, issues of ongoing cost orders made perhaps on interim applications and matters of that nature, because of how these rules will interface as matters roll out. But the bright lines are, of course, that we're going to see a change in the way that various people are remunerated, so counsel. We're going to see changes in the way, potentially, at least, you cost recover for the cost of detailed assessment or Part 8 proceedings about costs. All important issues, because they're going to have to be addressed within your own case planning as to how you deal with cost recovery going forward and how you advise your client about cost recovery going forward. So again, just bringing those strands together, when you obtain the slides from us with the hyperlinks, I do recommend that you embed those links perhaps onto your desktop so that you can regularly go back and see each of these developments as they come through, because they are by no means linear. By way of example, the initial suggestion from in July of 2023 from the Ministry of Justice, that set out 6 broad headings, where the cost of assessment should be fixed, whether there should be fixed cost for Part 8 costs-only claims, the recoverability of inquest costs, restoration proceedings and the like, and the issue of providing for the recovery of advocates' preparation in cases which are settled late and are not catered, and whether the fixed trial advocacy fees in the PD to Part 45 should be uprated for inflation, and if so, by how much, and then, of course, whether it should be made explicit in respect of clinical negligence claims that an early admission of liability must be made in the pre-action protocol letter of response. Now, when that then eventually got before the Rules Committee and they were discussed and debated, the circumstances, if one looks at the minutes each meeting, you would see that by December of 2023, insofar as extending fixed recoverable costs was concerned, towards fixing costs for Part 8 proceedings and for assessments generally, then that's had a bit of a mixed old journey. At one point it was sidelined, whereas now it's been brought back into focus and now seems to be full steam ahead for October of this year. But the point I want to make is, don't just read one source of information, assume therefore that because it's been flagged, it's likely to come in. What you need to be is aware ongoing as to where the changes are coming from, what drafting is being done by the Rules Committee to address those, and when, if they are to be implemented, what is the likely form of that implementation, and when is it likely to be implemented? And again, why? Because it strikes me that ultimately it's going to feed into the information you need to give your clients in order to discharge your obligations to give your client the best advice throughout the proceedings as to costs. So on that note, I shall bounce back to Andrew.
Thank you, Craig. I think it's interesting that Craig stresses the importance of using a variety of sources to keep abreast of that. And I think I must echo that. One of the points that struck me when preparing for this seminar was that if you looked at the CPRC minutes for December, I think it might have been an earlier month, they indicated that they were not minded to progress with any reform to cost assessment of fixed cost cases, no fixed Part 8 costs, no fixed costs of the assessment. Then, of course, 2 months later, the government says, well, actually, we are going to proceed with that. And so initially, if you look at these things, you might think, my God, there's a constitutional crisis here with the government setting policy and then the CPRC refusing to implement it. But I think the answer is much simpler than that. It's one which is based upon chronology. The minutes came first. The government has now set the course of what policy should be. Whether that then comes through into what the government envisages is perhaps another matter. I also think it's significant as well that you weigh these sources skeptically. And I'll tell you what I mean by that. I think it was in the 13th century that the judges stopped the practice of adjourning cases and sending a letter to Parliament to ask Parliament what it meant by given statutes that Parliament had passed, which in hindsight is actually quite a sensible way of proceeding on one view of a case. But because that practice was dropped, we developed the modern practice of the separation of powers, legislature, executive and judiciary. And so judges interpret the rules provisions by reference to what they say, not what those who drafted them actually go on physically to say they meant. And when you look at the Rules Committee minutes, you do see several examples where they set out what they believe the rules mean. But it's entirely possible that the rules might be interpreted to mean something else. So, fixed costs, love them or hate them, they are here to stay, at least for the foreseeable future. But perhaps we can leave that topic noting that it's an election year, and it may yet be that there will be changes afoot from an incoming administration. We must wait and see. So shall we move on to guideline hourly rates, Craig? And if I give a little explainer on that. In terms of guideline hourly rates, I'm sufficiently old that I remember the introduction of the first lot of guideline hourly rates and the resistance in certain parts of the country to having guideline hourly rates set for them. And in particular, one judge who took the view that living in his own particular part of the world was sufficient compensation enough that he didn't need a guideline hourly rate for grade A fee-earning work. That, of course, is long in the past, but the history of guideline hourly rates has been complicated and vexed and not entirely happy. One example of that, perhaps the most obvious, was that after guideline hourly rates were set for 2010, they then rusted into position with no update and no agreement on how they might be updated for effectively 11 years. There were, of course, attempts to get matters moving, in particular the infamous Foskett Review, but of course it was under Sir Stephen Stewart that the Gordian nut was cut. The Master of the Rolls quickly moved to adopt his recommendations, and we had guideline hourly rates in 2021. Those have now been uprated with effect from last month, 1st of January 2024. But perhaps the more interesting point is to note what the Master of the Rolls also did at the same time that he indicated there would be an increase in January. In effect, relating back to the costs review of the Civil Justice Council in May of 2023, he adopted the recommendations of that particular working group, which means there's a lot more change to come on the horizon. The first point is that guideline hourly rates are here to stay. There have been calls in some quarters for them to be abolished. The second is that although various indices exist to measure inflation, the consensus now is firmly on the SPPI index rather than RPI or anything else. There is to be a move to introducing guideline hourly rates for council, which is a particularly large can of worms, to which I wish them good luck in opening and unpicking. There is to be a detailed review in 2028, which is meant to be a root and branch consideration of this point. And in particular, it's at that stage that things such as remote working, and whether that makes a blind bit of difference to what is a reasonable hourly rate, the costs of information technology, whether they drive overheads up or bring overheads down, and possibly looking forward with a little bit of foresight, artificial intelligence and the degree that that gives for automation of legal process will presumably all be factored in to that sort of root and branch review. It might also cover some clarity or give some clarity on a test for departure from guideline hourly rates. And that could be quite significant. Many judges in the SCCO will regard the guideline hourly rates as a starting point, but no more. Further out into the regions, there are many judges who would take the view that the guideline hourly rates have a degree of consistency and simplicity that they like, and therefore you need an exceptional case in order to justify a departure from them. But be that as it may, that may well be part of the review in 2028, in which case we may see the ghost of Wraith and Sheffield Forge Masters finally laid to rest, and a bit of modern thinking as to the significance of geography or not when calculating a solicitor's reasonable costs. So that's my overview. Craig, what would you say about where we are on hourly rates?
Thanks, Andrew. Well, of course, those of you who, unlike Andrew, weren't born in the 13th century, probably are more akin to understanding and dealing with the guideline hourly rates that came out of the committee chaired by Mr. Justice Stewart. And therefore those that come out of 2021 rather than those that came out of the early incarnations that led to the 2010 and those before. But there is something to bear in mind, fundamental. The up to 2010, and arguably also in Foskett's venture into this area, the guideline hourly rates were a product of what was believed to have been at a point in time what local practitioners said was the cost of time in their area plus a care and conduct uplift, and then that was adopted by the local courts, and then that became the charging rate in those areas, and then that eventually was brought together. That became the early parts of the guideline hourly rates, and then they were, broadly speaking, raised in line with inflation. Now, of course, those of you who are more au fait with the 2021 guideline hourly rates, of course, will be aware that the process by which they were set moved away from this idea of inflation. They were a curiously new, self-fulfilling set of rates in that they were predicated on what judges who assessed costs had in fact allowed. So a rather curious way of looking at it. Nothing wrong with the way of looking at it, but it was completely different than the way it had been done before. So when we then move forward from 2021, in which the evidence for the 2021 guideline hourly rates had been predicated on those cases that had been assessed from 2019 and 2020, you then moved into the 2021 rates, and noise is being made post-2021 because of the heightened rate of inflation in this country, and where should we go? And of course, that then led to the Master of the Rolls, Sir Geoffrey Voss, and the amendments that were announced and published in December of 2023 and came into being in January of 2024, namely these uprated rates, which I have to say, I don't know whether Andrew is of the same view, sort of came in under the radar. Not a lot of people seem to have been aware of them. People weren't aware that rates had gone up, and I'm still seeing, certainly in summary assessment costs, situations where we're looking at the cost of the costs, where hourly rates are simply not being uprated, despite the fact that some of that work will have been done since the beginning of this year. So that they weren't really brought in with a great deal of fanfare. But what they are, they appear to be nothing more than an inflation-based uplift. And that inflation rate, as Andrew said, is the SPPI. And the basis of the SPPI, of course, is different than the RPI and is different than the CPI. For those of you who don't know the difference, you can be forgiven. It does rather strike me as being a lot of acronyms for no distinct purpose or benefit. But the distinction, as I understand it, according to the god Google, is that the RPI is similar to the CPI because it's calculated using a basket of different goods and services. However, the CPI doesn't take into account housing costs. And the distinction between the CPI and the SPPI, the Service Producer Price Inflation, is that in the SPPI, then it measures the prices that UK companies receive for their services and for their goods. And so, in effect, it is somewhat akin to the same process that was done for the purposes of the 2021 guideline hourly rates. It is, well, what were you as a service provider given for doing that work, and what were you paid? And so it at least has a symmetry by way of an inflationary lift to the process that led to the 2021 guideline hourly rates. Ultimately, they're going to be reviewed. Ultimately, they're going to go up by inflation. If inflation is high, then we'll see them rise. They are still, and this is important, they're still, of course, at this moment in time, still seen as being, by most experienced judges, certainly who are not undertaking summary assessment, but detailed assessment, as being nothing more than a touchstone, or as Andrew said, a starting point. That I do believe, and have long believed, is a strange, archaic process that seems to endure. If they don't have the basis of currency, either because they're outdated, as they were up until 2021, or because they don't in fact reflect what the costs of services are, then there's little point in having them. If they're meant to be nothing more than a rough and ready touchstone for a busy judge at a summary assessment who knows nothing about costs, then I'm not sure that a set of rates that appear to be followed only in the breach are a correct measure of anything. It seems to me that what you should have is a set of rates which are capable of being communicated to a client as being the going rate. That those are the rates that you could share with your client with a degree of specificity, and that they should reflect, if they're going to be raised by reference to the SPPI on an annual basis going forwards, that they ought to reflect what is in fact the price of goods and services that are being received by practitioners in the legal sector, rather than some odd touchstone that is to be departed from by reference to the 7 pillars of wisdom. So whilst it's encouraging to see that there is now a dynamism towards raising the guideline hourly rates, as opposed to the status prior to 2021, when we were stuck with these 2010 rates that had an endurance that was quite outstanding, really, given the affliction of the 11 years in between. But I do believe that if you are going to have that kind of annualized raise of those rates based on a rate a process of establishing a rate that is of itself referencing to the cost of services, then we ought to really relook at this idea that they are just a touchstone or a starting point, and perhaps move more to seeing them in a more positive light, where they can be a more accurate touchstone, if for no other reason than it would allow clients to be given a more accurate basis of what it is that they're likely to find deducted from their damages further down the line. But I agree with Andrew's observation, the point that I'm not really sure, now we've got National 1, National 2, and then 3 bands of London, that we need that kind of disparity anymore. I'm not sure it reflects the reality of how litigation is conducted in this country. I accept wholeheartedly, by the way, that most sectors of industry accept that there will be a London weighting. So if you're working in London, there'll be an enhancement for that process. That is not a situation that is just restricted to the legal sector. But I do wonder whether the notion of National 1 and National 2 really has any reference these days, and whether geography really is any longer any assistance at all. I appreciate we haven't condescended yet into any form of research into whether or not everybody working from their garden sheds means that it's cheaper or more expensive to run a litigation firm, or in fact whether it changes it at all. But I do wonder whether or not you being based in Manchester is any different from you being based in York or matters of that nature. People take on cases throughout the country, and ultimately they're going to take them on because they believe that they are commercially viable for them to earn a living from. And geography, really, quite frankly, and the idea of a guideline hourly rates as a jumping off point or a touchstone, it is, to my mind, just not helpful to the overarching need for clients and solicitors to know what it is they're being charged for, and in the end result, the profits that solicitors can make. Because ultimately, whether we like it or not, that's why we're all here. It is to ensure that we get paid for doing the work that we do, and therefore you need, to my mind, a greater degree of exactitude, both at the outset and subsequently once the detailed assessment or summary assessment has been undertaken.
I think that's so, and I think, if you sort of strip it back to first basics, what is the purpose of a guideline hourly rate? Is it meant to be a reflection of what the market is permitting solicitors to charge, market rates, or is it a rate set by the court on the basis of what is thought to be a reasonable and proportionate hourly rate for a paying party to pay? And at what point do you move away from having guideline hourly rates to going down the route perhaps of having fixed hourly rates if you favour the second consideration over the first? But it may be that, in effect, we're about to be swept under by an oncoming wave of technological change. We've had a question, Craig, which is quite a good question, which says, is there going to be any consideration as to firms who are looking at moving away from the billable hour to either a fixed phase approach and or a total value-based pricing approach, possibly more for non-PI matters, but firms looking at AFAs all the time, particularly panel firms? And that, I suppose, brings us to the elephant in the room, which is this. We have seen a situation whereby costs are assessed on the basis of units and hours, when everybody knows full well that a lot of the paper contained in the solicitor's file or the PDFs on the electronic bundle are prepared using precedents and templates, yet are priced as if the document had been drafted from scratch. We also know that when somebody charges a unit, they don't charge on the basis it's taken them exactly 5 minutes and 59 and a bit seconds to do a particular task. It's an irreducible minimum charge. And it means that solicitors can charge many multiples of what would be their hourly working week if they know how to charge for their time properly. So in those circumstances, we're already parting company with reality that the hourly rate actually applies to the 60 minutes in the hour. But what would happen if you had a situation where, for example, it was a catastrophic personal injury claim, and the solicitor said to the client, I'm going to charge you a fixed fee of 250,000 quid for all the work we do on your case up to the issue of proceedings. From the issue of proceedings to the point where it's set down for trial, we'll charge you another 250,000 quid for all that work. And then if it goes to trial, the further tranche is 250,000 quid. So if it goes all the way to trial, you pay us 750,000 quid. And if we internally spend what might be £1 million worth of work on your case, you benefit from that because we're undercharging. Could you do that as a fee arrangement? Well, you can contract on whatever terms you want with your client, but what would the court make of that sort of arrangement when assessing costs? And I said to one of the retired judges, what would you do if effectively you got a 1 or 2 page bill which simply set out these fixed fees which were charged? And the response, quick as a flash, was, well, I'd strike it out, of course, because the bill wouldn't set out the time spent on the case, as it must, according to the practice direction, and which I would have to look at as part of the overall assessment of costs under Part 44.4. But I think the point is one that's only going to grow. If you have a situation where you're automating more and more of your processes to the extent where on the horizon you can see you might very well have artificial intelligence-driven computer programs which analyze disclosure documents for you, doing keyword searches, pulling out the relevant points and so on, where you don't have trainees or juniors going through boxes after boxes of medical records and so on. How do you fairly price and charge for the value contained in that work? And I think that is a point that we'll be coming back to probably sooner rather than later. Craig, any thoughts on that?
Well, I think we're already pricing work by way of phases. That's the very essence of fixed costs. You'll get X for doing Y work. So we're already embracing a movement through that process of fixed costs away from the idea of 6-minute units and billing by reference to an aggregate and a multiplication of an hourly rate. So I think we need to just move our mindset, and the industry needs to move how it approaches this. Certainly, I mean, I can't remember if my memory is playing tricks on me, but I seem to recall that when Sir Rupert Jackson was dealing with his initial preliminary report, he did ask and invite Mr. Justice Stewart, when I think before he was elevated to the High Court bench, to undertake a review into the use of the 6-minute unit and hourly rates, because I know it was something he felt quite passionately about, because he said you could effectively bill. You could do 10 lots of different one minute work, and you build your hour because you're billing by a minimum unit of 6 minutes, whereas in fact you only actually work for 10 minutes. And so he had some resistance to the notion that we were all wedded to the 6-minute unit, but I just, it wasn't picked up, and whether that was because it just wasn't at its time, I don't know. But also, there's this idea outside of fixed costs of billing by a phase. It just doesn't seem to be attractive. One, for the reasons Andrew just said, that I think judges would find it very difficult, because they'd say, well, what is the contractual basis? How do I measure this party? And it causes difficulties, it seems to me, with the indemnity principle. in any event. And it has that hue of a sort of damages-based agreement about it, doesn't it? That you're being paid by reference to something other than the work you've done. You're getting paid because you contracted to do something by phase. So bringing those strands together, it seems to me that we are moving towards a time when we are more likely to see an acceptance within the industry that we bill or agree to bill or are remunerated by way of phases, because that is in and of itself nothing more than a manifestation of fixed costs.
And I think there are other problems as well, Craig, because once you start paying someone by phases, then you get this incentive built into the system for them to move from phase to phase as quickly as possible, because they collect further lumps of 200 quid each time they pass go, effectively, as they do so. Yet, at the same time, the increments that they get by going through each phase are not sufficiently large that they strike immediate fear into the likely paying party's heart to make them want to act more quickly to settle the case. Whereas it could be said that an award of unquantified standard basis costs can have that chilling effect and force the parties to settlement, which in a sense has to be a good thing, because otherwise the court system would collapse through too many cases going to trial.
There's the fact that I rather suspect that the paying party would not be motivated to pay by way of phases. They would quite rightly stand there and say, well, hang on a minute, where's the indemnity principle in all of this? We're only required to pay you that which your client is liable to pay you under the indemnity principle. And the way we calculate time outside of fixed costs is by reference to 6-minute units and an aggregate of hourly rates. So I rather suspect that there could be arguments that they shouldn't be billed for it, so it wouldn't have the chilling effect on them anyway, because they'd stand there quietly going, oh, well, I wish you well, having agreed that with your client, that subsequently and further down the line, your client doesn't come looking for you on a solicitor-owned client assessment, saying that those costs were, by their very nature, inherently unreasonable, because they were likely not to be recovered because they were unusual and unreasonable in nature and amount. But that's perhaps another point for another day. We're going off on one here.
We are. There is one question we've had on fixed costs, which I think we'll just deal with before we move on to the next topic, which is this. It says, I haven't dealt with intermediate track fixed costs yet. May I welcome you to the club? Neither have I, because it's all far too new in the personal injury context. But the writer says that if there are more than 2 medical reports, the intermediate track does not apply. Is this correct? The answer is, in theory, it doesn't. But of course, this is opening up issues as to how the courts are going to exercise their discretion upon allocation and assignment within an allocated track. And then the crux of the point, any tips for shuffling up the intermediate track complexity bands, or is it too new to advise? Well, my thought upon that is the complexity bands are extraordinarily opaque to the intermediate track. It's very difficult to see how they get hooks into a particular case in particular factors and whether and how to predict what the decision will be. But it may be that there is a further complication which falls to be considered. Suppose you have a case which is worth £50,000 and would be an intermediate track case, but due to clever admissions or concessions, by the time it comes to allocation, it's of fast track value. So the judge allocates the case to fast track. Now, the rules as drafted provide that the fast track rules apply before as well as after allocation. But it would appear that there is no mechanism in the rules as they are drafted to give a solicitor the difference between what would have been an intermediate track case when it started and when all the work was done to get it to the point of allocation, set against being hit with fast-track costs throughout the life of that case, simply through clever concessions being made at some point prior to allocation. So that is going to be a real issue, I think, going forward. Any thoughts, Craig?
Well, the overarching thought I've had is linking back really to the Ministry of Justice's consultation documents, and then the Rules Committee's approach to drafting rules and moving matters forward so that it demonstrates the will of Parliament in these areas. And whilst one interpretation of what's going on here is that there was a joined-up plan that led to these rules, and then all that we're doing here is slightly tweaking them and improving them. That would be one way of looking at it. The other way of looking at it would, of course, be that the original rules were so unfit for purpose. They were akin to the windows on a Boeing 737. They appear to be optional and may fall apart at any moment. It just seems to me that there are so many tweaks going on with these rules that you do question whether or not they're fit for the purpose that they're aimed at, and whether these laws of unintended consequences that one regularly reads on everybody's blogs, and which quite rightly the author of that question has raised because it's vexing them, that there isn't actually an obvious answer to this. And so if any of this joined up thinking in the imposition and rolling out of fixed costs was intended somehow to make matters certain for practitioners, certain for clients, certain for institutions and entities that are usually at the paying side of costs, then I think they've fallen at the first hurdle. Because it strikes me there are going to be so many applications dealing with so many esoteric issues arising out of those sorts of issues, namely where it's manifestly unfair that you'll find yourself having done all the work, that you can't then get reasonable proportionate remuneration for it. And in fact, it's going to change litigation behaviours. Parties are going to be reluctant to narrow issues on the most spurious of grounds, simply because they want to remain where they are until such a time as they've been allocated, and they will want to keep hold of any factors that will allow them to get traction at moving up the scale of complexity and until after allocation. And so you're going to create a different approach to litigation. You're not going to have an approach of early resolution and narrowing of the issues in circumstances when, if you do that, you will see a huge reduction in the amount of remuneration you're going to get. So, again, I think this is all the more reason why practitioners who perhaps as of yet have not had the imposition of the October 23 rollout of fixed costs need to keep their eye very much on the developments of what's been coming out of Ministry of Justice and what's being done by the Rules Committee, because they need to see where the, to quote the sort of Drive to Survive Netflix series, the upgrades are coming from and the patches that are going to make things go faster and smoother. Because I rather suspect at the moment, if you were trying to run a business, you wouldn't be trying to run it on this basis, because you just can't truly plan as to what you're going to get in any particular case, and what would be a tactical and proper approach to take in circumstances where, quite frankly, reasonable litigation behaviour by a claimant solicitor in narrowing the issues and reducing matters of contention are likely to lead to them being unremunerated for work that they've properly done in order to get to that point.
We'd better move on, Craig, because we're now at 443. So do you want to kick off on this medical agency?
Yes, so let me pick up on that. Thank you. For those of you who have been following this, this is a strange re-emergence of an old argument. For those of you who recall the early days of the decision of His Honour Judge Cook in Stringer and Copley, and which then led to the arguments in Woolen and Fowler, all of which were engaging themselves with whether or not it was reasonable to instruct an agency to obtain a medical report, and then if you've done so, how the court is to remunerate the cost of that medical report, in circumstances when the only invoice that the court will have is likely to be the invoice from the medical agency and not a fee note as is envisaged by the Practice Direction of Part 47 at Article 5.2. Now, very much when one went back in time to Stringer and Copley, the situation was that, in broad terms, the court needed to have before it some indication of what the medical professional is charging and what the agency is charging in order that the court can then weigh in the balance what is a reasonable and proportionate fee for the paying party to pay. Now, that matter really had lost some of its energy over the last few years. There'd been a brief run out in front of His Honour Judge Graham Wood QC in Liverpool, I think in a case called Beardmore and Lancashire County Council. But overarchingly, it didn't seem to be getting ahead of steam until, that is, it comes before the Manchester County Court on a first appeal from a decision by Regional Cost Judge Harris in Northampton General Hospital and NHS Trust against Luke Hoskin, where His Honour Judge Bird on that first appeal really took the view, almost in a very narrow way, that because the practice direction in Article 5.2 requires you upon applying for a detailed assessment to place before the court the fee notes, that in fact, if what you're doing is you're putting in front of the court an invoice from a medical agency, then you're not in compliance with the expectation of the practice direction, and what is in fact required is a breakdown. And if you don't give a breakdown, then you're not going to recover your fee. Now, of course, what happened in Northampton with his Honour Judge Bird was that that led to an order for disclosure of the breakdown, and that was then taken. Permission of appeal was obtained and secured, but subsequently Premex wouldn't give, as I understand it, an undertaking to pay the costs of this argument if it all went wrong, and so in those circumstances they didn't fancy the argument that would clarify the issue. They obviously preferred to keep having the same argument over and over again in front of different district judges up and down the land. And so we're no further forward. And then on the opposite side of the equation, you have very much the approach of His Honour Judge Graham Wood in Beardmore, which was a case which was largely followed by Regional Cost Judge Jenkinson in a case called Sefton, albeit that was about non-party disclosure. It ultimately turned on the same question. But the difference in approach there was that Judge Jenkinson took the view, well, the court is only interested in what is reasonable and proportionate. And ultimately, that's a matter of the court's own knowledge and its own experience. And, of course, the court could call for evidence from both sides if it was contentious, or in fact the paying party could put in its own evidence of what it had paid in other cases. What I think comes out of the two cases that struck me as being important was that insofar as the court was approaching this from the strict reading of the practice direction in Northampton General, that was in large part predicated by His Honour Judge Bird saying that what was the view in Stringer and Copley with His Honour Judge Cook back in 2002, namely that you need to know what the breakdown is in order to be able to assess, rings as true today as it did then. Well, that's diametrically opposed to what Judge Jenkinson's saying, which in effect is, no, I'll know it when I see it, and I'll also know when I don't see it. And I do wonder whether or not the reality of this is that in 2002, requiring a breakdown in those circumstances, there was perhaps more of an imperative for that. But in 2024, 2023, does a court on an assessment of a medical reporting fee, and it's the cost of obtaining that medical report fee, is it really assisted by knowing how much went to the doctor and how much went to the agency? Or is it really an argument about paying parties wanting to know whether or not they can run a secondary argument in fixed cost cases based on an assertion, well, you've already had that money built into your fixed costs, and what you're trying to do, claimant, is to get a second bite at it? Because I do wonder if this is now going to develop a new life of its own. We're now going to see an increase in these sorts of challenges, and if there's a requirement to effectively break down these constituent parts, where does that end? Is it a reasonable challenge to say, well, we have a fee note of, say, council, but we'd now like to know how is that in and of itself broken down, particularly in circumstances where there's a headwind now to suggest that council should also have a guideline hourly rate. I'm very much of the view that this will no doubt keep many of us in work having arguments that have been around for 22 years. But I do wonder whether or not the actual way to deal with this is to simply call for evidence, rather than getting into the situation that His Honour Judge Bird did, where he ordered Premex to put forward their breakdowns, which seems to me to be an inadmissible approach in any event, because you're ordering a non-party to do something which could arguably be commercially sensitive in circumstances where they've neither been brought into the proceedings and nor have they been put to their election under the Pamplin process to prove matters by an alternate method. So whilst I'm not criticising Judge Bird's decision, I am noting that Judge Bird sits on the Rules Committee, and that therefore his simplistic approach may be the one that finds favour ultimately going forwards. But I do question whether or not it is a argument of merit, or whether or not really the way to cut the Gordian knot is simply to identify that judges are now much more au fait with what the run-of-the-mill experts' reports are in the vast majority of cases, and what is a reasonable cost for it. And they're not really assisted by a breakdown of what an agency got and how their buying power was able to drive down the price of an orthopaedic report.
Yeah, and I think it's a nice division, isn't it? The breakdown issue. But then the question, does the provision of a breakdown actually make a blind bit of difference? Once you accept that the production of a medical report is more than the fee paid to the expert who provides the expertise, there's the overheads, the consulting rooms, the sourcing the medical records, the administration and so on, then to what extent do you need to know more than what is the reasonable proportionate sum for this? And the notion that, the man on the street can phone up and get the same price as somebody who is offering 500 instructions, to my mind, is fallacious in any event. But I think, Craig, you're absolutely right. 22 years on from Stringer and Copley, and the point is still coming round again, as it no doubt will for the next few years. We'll have to see how it all pans out. Now, we've had a couple of questions on this. The first is, would a breakdown assist in calculating the correct ATE premium? Well, that's a different point, because the issue of deconstructing an ATE premium has been argued uphill and down dale, not least in the Claims Direct and the accident group test cases of 20-odd years ago. And by and large, an ATE premium will be made up of many elements. It will be made up of the burning cost. It will be made up of the administration and marketing costs. It will be made up of profit and so on. But by and large, courts don't go further than assessing in broad terms whether the overall figure is reasonable and proportionate. And that is, in a sense, where we may end up with on agency fees. In relation to the disclosing agent's breakdown only being a requirement of a detailed assessment as opposed to, I suppose, a summary assessment. The reality is, of course, that a summary assessment, you're painting in broad strokes in primary colours. And if there's a real point which requires investigation, then the judge should be sending the case off for a detailed assessment. But the reality of the matter is that if they did that, the courts would be choked with assessments for relatively small sums, and people just get on with it at a summary assessment point. We're now in the last 5 minutes, Craig, so we'd better get our skates on. Shall I start with QOCS? QOCS, in a sense, is the gift that never stops giving, because the old problems are well known. On the 6th of April last year, the rules changed. But of course, because there's a cut-off point with the transitional provisions, the old system runs in tandem with the new system for many years yet. So you must remember, is your case subject to the old rules or the new rules, as that's going to be potentially very important. But problems remain. And in terms of the case law, it still keeps coming. There's just 2 cases which I thought were worth noting. One of them is called ABC and Others against Derbyshire County Council and Others, which was what would be described as a mixed claim under Rule 44.16. And by that, there were in the one set of proceedings a personal injury claim and a mix of other claims, as well as negligence. There are issues of human rights, false imprisonment, and so on. The claimant loses at trial. The defendant's position is, well, it's a mixed claim, therefore the court has discretion to disapply QOCS. We therefore want our costs. The High Court judge, who's Mrs. Justice Hill, says, yes, it's a mixed claim. Yes, there's some costs here which are attributable to other elements in the personal injury claim, and doing the best I can, taking all the factors into account, you may enforce 5% of your cost claim against the defendant. So that meant, in crude terms, that 95% of the costs would remain unenforceable as against the losing claimant. The other case that I thought was worth looking at is that of Clark and Others against Adams and Others, which is the attempt to sue Gerry Adams and the Provisional Irish Republican Army for injuries suffered in the bombings of 1973 and 1996. This is a very interesting case for a number of reasons. But the reason that caught my eye was that at a preliminary hearing, which dealt with various applications being made, one of the applications was seeking declaratory relief as to whether QOCS applied or not at all, in circumstances where the damages being sought by the claimants were vindicatory and nominal of £1 only. They wanted a judgment, not compensation. And Sewell, who was the High Court judge, Mr. Justice Sewell, said not only does QOCS apply, irrespective of what the quantum of your case is, it is appropriate to give declaratory relief. That might be quite important if you have cutting-edge litigation where there may be an issue as to whether QOCS applies or not. What about yourself, Craig?
Well, I'll just pick up on 3 points, really, arising from those cases that have been issued after the 6th of April of last year. And really, a practice point. It strikes me that if you have not looked at your client care letters since then, as a firm, you need to look at them, because you're now you now have an added dimension whereby any costs that flow adverse to your claimant client can now be offset not only against damages but also against costs and interest. And whilst solicitors are often confused as to whose costs they are, of course, in the eyes of the procedural law, the client's costs. And so you need to be addressing your client in your client care documentation as to what's the impact of the potential that they could have a reduction of their costs. If you have a conditional fee agreement or retainer with your client that allows you to, and you do in fact, deduct from your client any shortfall in costs, then of course they need to be on notice that in the case of a QOCS engagement, where the adverse cost is being charged not only against damages but also against costs and interest, there needs to be an agreement between solicitor and client as to which comes first. Does it come out of the damages? Does it come out of the interest? Does it come out of the costs? And in any event, if it comes out of the costs, and therefore there is a deduction from those costs, is the client still liable to pay the shortfall to the solicitor, come what may? Now, the obvious answer to that should be yes, they should. These are the claimant's costs. If the adverse cost is deducted from the cost that they're recovering, then they should still remain liable for that sum to their solicitor. Of course they should. But in the world of no win, no fee, and clients who believe they'll never have to pay anything, if you've not got your client care documentation up to date, you haven't got your conditional fee agreement up to date to make that clear, and you're not on top of ensuring that either that when there's a Part 36 offer or perhaps when there's an interim cost order, you're not bringing your client up to date about the impact of QOCS, then you could find yourself, in a practical sense, in difficulty and in conflict with your client. So whilst Andrew speaks there to some very interesting developments in some of the case law, certainly in mixed claims, and this novel idea of declaratory decisions at the outset so that you know where you stand with QOCS, perhaps in cutting-edge claims or quite esoteric mixed claims, there are matters of professional practicality that I think, shall we say, are more fundamental to practitioners, and that's what you need to be looking at. Make sure, go back, check, what does your documentation say about the QOCS provision post April of 2023, and does it inform the client as to what's going to happen if damages, costs and interest get watered down because there's an adverse cost order flowing to the defendant?
Yeah, I think so, Craig. And of course, fixed costs themselves have meant that a lot of conditional fee agreements need to be adjusted, amended, redrafted in order to deal with the contingencies that can arise. But you know what? We've actually sucked the lemon dry. It's now 5:01. What I can say to some queries I see in the chat is that this is recorded. We do have the King's Chambers YouTube channel, which I can tell you is scintillating viewing, so you're welcome to subscribe to that. And this recording will be placed on that in a few days' time. Seminar notes, seminar slides will be sent out to people who have signed up to this. But I'm afraid that there is simply too much, even in the 4 topics that we were able to select, really to do anything other than to draw a line, because the law never stops growing. We will, of course, be back later in the year, and we look forward to seeing you then. But until then, it's goodbye from me, and thank you very much for coming.
Thank you very much, everyone.
Cheerio.